Greetings, my name is Patrick Phancao with the Asset Protection Center. I am an estate planning attorney focused in the field of asset protection and elder law out in the state of California and Florida. Let's talk about a disclaimer today. What is a disclaimer? Especially, as you know me, by now in the context of asset protection. A disclaimer is basically the renouncing of an asset, especially in the context of an inheritance. Now, as you can imagine, it is not common for someone to reject something that is coming their way. It could be for personal reasons, because the beneficiary was not close to the individual that is gifting the asset and has some personal vendetta of some sort, so he or she elects to push it away. Or there might be some other financial reasons. In California, in order for a disclaimer to be valid, there are certain requirements. First, it must be in writing. It must be irrevocable. It has to be within 9 months of the vested right of that interest. So from the day you are put on notice that you are supposed to inherit, let's say, a portion of money, $250,000, that disclaimer must happen within 9 months of that window. And finally, and naturally, the individual making the disclaimer must be of sound mind. So what ends up happening if you do so within the context of asset protection is that a creditor cannot make the claim for that inheritance because you do not own the asset as you've disclaimed it. Now, naturally, there is the potential that the creditor might attempt to void this disclaimer based on the timing in which it took place. So, but that's for another day, because that entails quite a few issues. So hopefully that gave you a little bit of a working background of what a disclaimer is. If you want to find out more, however, visit us, www.assetprotectioncenter.com, or if you have a pressing matter, call me, 714-966-2646, and we'll discuss your situation. Thank you for watching, and I'll see you next time.